Now, 5:30, a federal judge in Wilmington is now considering whether to dismiss a GOP lawsuit that would require more than 200,000 registered voters to cast provisional ballots.
It's a story that Queen City News has been following since August. The Republican National Committee and the state Republican Party sued to have nearly 250,000 people thrown off the voter rolls. Republicans claim that the state violated the Federal Help America Vote Act, saying that people who registered to vote prior to 2023 were not required to provide their driver's license or social security number on registration forms. So let's bring in Chief Legal Analyst Collie Frodes.
All right, Collie, first, after hearing that, what stands out to you in this case?
What stands out is that the form didn't get updated properly, and so they weren't informing people at the time that they were registering that they had to capture that information, because this form they were using was outdated. So that stands out to me. That's kind of how we got here. But they shot back and they said, well, a couple of things. That doesn't mean this person didn't have a right to vote, didn't have a lawful authorization to vote. That just means we didn't capture their information. And it means that also we can't make the logical leap to say that these people will be able to vote illegally, because even if they go to vote, they have to show ID. And if they registered improperly, whatever we get to, we'll be able to get an opportunity to have them show some form of an ID, because if they registered and they didn't have an ID, they would have required them to prevent some type of ID.
So when it comes to the provisional ballots, I mean, they are counted after election officials are able to verify that this voter was able to vote and eligible to vote. So if that's the way the court goes, that they're required to do these provisional ballots, how can those voters ensure that their vote is counted?
Great question. I mean, so they're asking the court for two things, right? They're first asking the court, they were asking the court to make sure they did some type of purge of the voters. But there wasn't enough time for that. Even if a judge would have decided, it would have violated
the deadline, right?
They missed the deadline. But even within that September 5th deadline that they asked them to do it, it was already past the 90 days deadline that the federal law requires, so it couldn't have got done. So if you're now asking, will the likelihood of a judge saying that he'll force people to vote provisional, I don't think that's going to happen. Why? Because voting already started. Voting starts today for us, early voting, but it already started absentee ballots before then. And so I think that it would be extremely hard for a judge to say that. But in the unlikelihood if a judge did say, you know what, I'm going to require these folks to vote provisionally. They'll walk into the location, they'll go through a provisional application. On that provisional application, it will solve the problem that Republicans are saying is the issue. Because on the front of the provisional application, they'll have to provide an ID and they'll have to provide the last four of their social. So at that moment, right there, those folks will be solving the issue that is the allegation of some type of voter fraud there. Because if you didn't have social, if you didn't have an ID, you won't even get a provisional ballot. And so I think it will be stopped there. But I mean, we don't even have to make that jump. I think it would be hard pressed, and we've seen some strange things happen. It'd be hard pressed to find a judge that could say in the middle of an election that's already started, where people have already voted, that potentially 8,000 to 9,000 folks that asked for a provisional ballot that registered to vote, that fall into this category, may have already voted.
Okay, so my question to you is this, and why? What's the argument then as to why you would want this case to be going back to state court where it originally started?
Well, I mean, the argument to go to state court is just numbers. We're all talking about numbers game. Let's talk about these whole lawsuits. Michael Watley, their whole process is sue, sue, sue. If you're not going to comply to what we're asking, we're going to do a lawsuit. And you're seeing suits across the country. North Carolina is no exception. So we wanted to go to state court, not federal court, because we have a better likelihood of getting someone that sits in front of the seat that will have an R next to their name. I mean, that's the only way that you can look at it. Court of Appeals in our state, heavily Republican. Supreme Court, heavily Republican. So if this goes back to the state courts, it will go through the process of making its way back up to the folks that you think will have a better likelihood of voting in the way that you think.
Real quick, you think that's going to happen?
I doubt it. I mean, and if it does, I will say this. Watley has said the fights that we're fighting may not be for this election. We're laying the foundation for the next 4 years.
Valid point.
And just Michael Watley, obviously the head of the RNC chair there. All right, thank you.